our law firm represents a lot of people charged with criminal harassment. Very early on in the process when they retain us, even at the first initial consultation, we carefully explain the court system to them. What are the general steps in their file? How long is it going to typically take if you decide to resolve it versus heading to trial? That's what I'm here to talk to you about today. So let's take a hypothetical where you're charged with criminal harassment today. The police arrest you and release you. You have no prior criminal record. They release you on a promise to appear or an officer in charge undertaking, and they give you a court date typically about 3 to 6 weeks down the road. You retain our law firm, say, a week later. What do we do? Well, first of all, the very first thing we do is we order the police reports. That's called the disclosure. All of the witness statements, video statements, any evidence against you, the Crown Attorney is required to provide it to us, pursuant to a case called Regina against Stinchcombe from the Supreme Court of Canada. Now, the Crown, they try to get that to us by the first court appearance, but they often don't succeed in that. But typically we'll receive it sometimes between the first and second court appearance, sometimes before the first appearance. That's the crucial documents we need to analyze your case. In the context of those documents and your version of events, receiving both of those, I'm able to tell you what your odds of winning are, where we should head with this case, and what our best bet is. On a cost-benefit analysis, should we proceed to trial, or should we take the best possible offer that the Crown's offering us? Best possible offer is a withdrawal. We're going to take that every time. Maybe a peace bond, conditional discharge, or maybe the Crown's asking for jail, and we got a good chance of winning, so we'll head to trial. The Crown's not being reasonable. These are fulsome discussions which I have with you when we receive the police reports, the disclosure. That may take several meetings. I receive your version of events. I want you to review the disclosure on your own as well, so you completely understand it and make notes for me. And we craft a statement for you, obviously in your words, but we might do multiple drafts of that. Now, you then give me instructions about what you want to do. Well, if I'm not offered a great deal, Mike, I just want to head to trial. You've told me I get a good chance of winning. Well, we can go do that. That's not a problem. Or, you know what, I'm guilty. Just get me the best deal you can. They got an overwhelming case against me. So armed with your instructions and my knowledge of the case about where we want to head, I set up what's called a Crown pretrial, fancy name for just a meeting with the Crown. And we just start discussing the case. The Crown has their viewpoint, I have mine. We discuss your background. We discuss, what's the Crown offering? Will they withdraw the charge? Is there any reasonable prospect of conviction? I try and convince them to withdraw the charge in an appropriate case. I might try to convince them, if they've got a case, to go for a peace bond because it's minor, or a conditional discharge where we avoid a record. Or, you know what? The Crown's not being reasonable. We have a pretty good case to win, and it's going to be a trial. Some cases just have to go to trial because the Crown's not being reasonable, or it's a 50-50 case. They're being reasonable. They think we can win. We've got a shot at it. So this discussion about trial issues, the Crown and I discuss all aspects of the case. Time management, we have to estimate court time. We have to know who the witnesses are being called, the legal issues, the factual issues, the applications that I need to bring if there's applications to exclude evidence, charter issues. These can be involved discussions on this type of case. We might need more than a couple of meetings. I report back to you about our discussions and give you an idea what we should do. I mean, it's all your decision making, but I make recommendations to you, but ultimately it's all up to you. Hopefully you follow my legal advice. Some clients choose to go to trial even when they're offered a good deal. That's totally up to you. In the meantime, we've had our first appearance, that was 3 to 6 weeks after the arrest. We filed that designation, which is the document where we're your lawyer. It's before the court. I'm named as your lawyer and Kruse Law firm. And in Ontario, the matter automatically goes over for 12 weeks. That's a protocol brought in during COVID. I suspect they're going to keep that protocol because it's working very well. And don't worry about the 12 weeks. So we're still doing the steps in the file. All the work on your file doesn't happen at this remand court. It happens in my office, it happens in the Crown's office, it happens when I meet with a judge. So you've said to me, look, Mike, they've offered a great deal to me for a conditional discharge. I'm guilty. I don't have a very good chance of winning. Let's do that. So what I might do at that point is have a judicial pretrial to have a judge approve the deal. So I organize that. The judge says, yes, that's fine. I can live with that. It's a joint submission the Crown and I are agreeing to. Now we can get a court date. So that court date that went over 12 weeks, I can bring that forward to deal with that guilty plea. That's not a problem. So don't worry about that. Because you see, the court dates are just a reporting mechanism. They're outdated. They should get rid of this remand system. I reviewed that in other videos. You should watch that. All the court dates are is a reporting mechanism for me and the Crown, for the Crown and I should say, to tell the justice of the peace what's going on in the case. It's kind of like reporting to your boss, what's going on with this project? And the court says, okay, I'll give you another 6 weeks to complete the next steps in the file. Think of it that way. We could do that by email. I don't know why they don't get rid of the system actually, but that's the system we're stuck with. So, what if the Crown says, you know what, I'll give a peace bond if you get upfront counseling. So we need 10 weeks of counseling. We complete that process, great deal. You enter peace bond, no criminal record, charges withdrawn. Again, we can move the court date forward. Now, what if you want to head to trial, we're not being offered a deal, you claim you're innocent? Well, we now need to manage court time. We need to have, in addition to my discussions with the Crown, where we're managing court time and talking about all the legal issues, I need to have the next step, which is called a judicial pretrial. I organize that with the trial coordinator. We get that date. So I meet with the Crown and a judge who's not the trial judge. We have, again, a very fulsome discussion about all the legal issues, all the factual issues, whether there's charter applications, what witnesses are going to be called, order of the trial, voir dires about excluding statements, you name it, we discuss it at that meeting. And the judge, Crown, and I estimate the trial time. Maybe it's a one-day trial if it's a simple case. Maybe it's 2 or even 3 if it's a very complicated criminal harassment. Once we've completed the judicial pretrial, and it might take more than one, usually one with a criminal harassment, sometimes more than one on a complex case, we're in a position to set a trial date. So where are we in the remand system at this point? Well, bear in mind, the matter went over 12 weeks. It's probably a rarity where we've had the judicial pretrial before the 12 weeks is complete. Usually we need another remand, sometimes 2 if it's a more complex case with missing disclosure, for example. But we set a trial date. So we're probably in a position, I'm going to say, in most counties to set a trial date to organize it with the trial coordinator, probably about 3 to 5 months after the date of your arrest, we're in a position to set a trial date. And when's that trial going to take place? Well, again, it depends on the county. If you're in Brampton, it's going to be a long way down the road. In Toronto, if you're in Walkerton, it's going to be a quick date. The quickest dates, and this is pretty ambitious in a smaller county, and our firm, we have multiple offices in Ontario, so we know all the counties in Ontario. The quickest might be 6 to 7 months. That's ambitious, by the way, after the date of arrest. The longest might be even up to 18. I would say the average is probably in the 9 to 15 months range after the date of your arrest. Bear in mind, your trial is supposed to be completed within 18 months of your date of arrest, or you might have a delay argument. So that's the trial process. And then we get ready for the trial. A lot of work is involved in that. Preparation, preparing myself, preparing to cross-examine the witnesses, submissions, legal issues, charter applications, you name it. There's literally probably dozens of hours of work involved in getting ready for one of these cases properly. And that's a continuum. You're starting to prepare from day one, but the real hard preparation for trial really takes place in that month before the trial, including multiple meetings with you to get you ready to testify in case you need to testify. So that's the trial process. That's the timeline. We'll call it 18 months at the max. Ambitiously, in a very county that's not busy, maybe 6 or 7, but I'm probably overstating that, frankly, even on the small counties. So what if you decide to plead guilty? Well, that can be done anytime, frankly. After we receive the disclosure, met with the Crown, I might not need a judicial pretrial to approve the deal, or I might, if it's a tricky deal. It's a joint submission. We can pull that 12 weeks ahead and do that anytime. Bring the matter forward and get it done. Or you might need to do counseling, for example, so we need to delay things. So in terms of resolving a criminal harassment matter, really, that could be done, ambitiously within 2 months. I doubt one. That'd be a rarity. You're looking anywhere from 1 to 5 months, depending on whether you need counseling, et cetera. But of course, we're trying to get this charge withdrawn. That's our ultimate goal, or winning the case. So I'd like you to watch all of my other videos on these topics, because I cover each of these topics, like the first appearance, what happens at a first appearance, what happens at a Crown pretrial, what happens at a judicial pretrial, how does a trial function, what's the trial process. Every one of these topics is covered. What is a designation, you name it, in all of the other videos. I just wanted to give you an overview today of the typical court process for a criminal harassment. One addendum to this is criminal harassment's a dual procedure offense. So I'm talking about the court process I just gave you is for a summary conviction criminal harassment. If the Crown elects by indictment because it's a very serious offense, or they have to elect by indictment if it's historical, in other words, if the charge occurred 1 year before the police arrest you, over 1 year, they have to charge you by indictment. You have a right to election to the Superior Court, judge alone or judge and jury. It's a similar process that I just said. The same thing's going to take place in Ontario Court of Justice, the workup of the file, the timelines. But at some point, it's going to get moved in the Superior Court of Justice. You're going to file an election document electing either judge and jury or judge alone. And it's going to be a longer timeline. Or you can elect to be tried in the Ontario Court of Justice. You have multiple elections. But if you elect to go up because you want a jury trial, or you think the Superior Court of Justice's judges are more liberal than the Ontario Court, every county's different. Some judges are more Crown friendly in the Ontario Court of Justice, some aren't. It depends on the county. That timeline is going to be much longer. I mean, the maximum timeline from the date of arrest to the completion of your trial at Superior Court of Justice is supposed to be 36 months, but in a criminal harassment, you should be able to get your trial on before that. I mean, let's just go through it. Maybe it's moved up to the Superior Court after 6 months of being in Ontario Court of Justice. Maybe you're going to get your trial on, with any luck, 12 to 15 months after that. But it could be longer in a busy county. And it could be much longer if you elect jury, because juries only sit so often. So again, I encourage you to read my other videos on all of these individual topics, but that's an overview of the timeline, the general steps, and what to expect for a criminal harassment charge, both a summary conviction and indictable charge. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.